Good morning, good afternoon, good evening, everybody, and welcome to this ICA webinar with the ambitious title of Archives, Access and Copyright, What Every Archivist Should Know. My name is David Sutton, and I'll have the pleasure and the privilege of chairing this session. I'm the editor of the UK Watch Copyright website and a former chair of the ICA's working group on intellectual property. I'm going very briefly to introduce our three panelists in alphabetical order, but you've had their biographies circulated anyway. So our first panelist is Avril Belfon, who's the government archivist at the National Archives of Trinidad and Tobago. Her long activism in Carbica has reflected the Caribbean region's great interest in copyright issues, and she'll be bringing her experience both in government archives and in copyright issues in the Caribbean to this session. Our second panelist is Dr. Jean Dryden, well known to many of you, I'm sure, as an archival consultant and scholar based in Toronto. For over a decade now, she has been ICA's representative at the World Intellectual Property Organization meetings in Geneva, and has written and published many articles and essays on copyright, which I'm sure many of you will have made use of. And our third panelist is ICA's new representative at the World Intellectual Property Organization meetings in Geneva, Dr. Victoria Stobo, who's a lecturer in record keeping at the Liverpool University Centre for Archives Studies. We've got a very distinguished panel for you here. The idea is that we'll ask very general questions and invite the panelists to run through those. There'll be time for interplay between the panelists. I will invite people to put questions in towards the end of the session, I think, so that we have a discussion between the panelists first. So as I say, I've got a number of fairly general questions to put to the panelists, and I'm going to start with a question which is about how copyright is relevant to the fulfillment of the mission of archives. How is it that copyright integrates itself into the mission of archives and archivists? It's a very general question. I'll ask Victoria to make a start for us. Victoria.
Thank you, David. First, I would start by saying that copyright is an intellectual property right. It needs no registration to exist. It comes into being at the point of a particular work's creation. So if we want to preserve and provide access to works, then we need to be aware of copyright. And we also need to be knowledgeable enough about copyright to negotiate those rights issues either at the point of deposit or thereafter. So if we want to make use of a work in our collections and it's protected by copyright, we need to be aware of that fact. We also need to be aware of the copyright that exists in the work that we create as archivists and records managers, and also to think about whether it serves our professional interests to assert that copyright or not. So I guess what I'm saying is we can see copyright as being prohibitive in that it stops us potentially from doing some of the things that we need to do to protect, preserve, and make our collections accessible. Or we can see it as being facilitative in that it allows us to make use of our collections and to preserve and protect them in different ways.
Thank you, Victoria. That's a very interesting point. So copyright not only in the archives for which we're responsible, but also in the works of the archivists as they conduct their custody of the archives. Jean, would you like to add?
Well, in fulfilling our mission as archivists, we often copy things. We copy things in order to preserve them. Because our holdings are unique and irreplaceable, we don't let people borrow our holdings because we are not like a library. So therefore, if they want to do research in a particular area, but they don't want to live at the archives, we provide them with copies. So copying is fundamental to the ways in which we fulfill our mission to preserve our holdings and serve our users. We also, copyright is a balance, and at the same time, we need to do a lot of copying in order to fulfill our mission, but we also must respect the copyright of the rights holders of material in our holdings. And as Victoria has mentioned, we also are creators of copyright material. So there are a number of points at which we must know about copyright.
Thank you, Jean. Avril, would you like to give your thoughts on this general point to start with? You're muted, Avril.
Sorry about that. Good day, everyone. Just to point out in terms of my bio, I'm recently retired, just of April of this year, from the National Archives of Trinidad and Tobago. So I'm still getting accustomed to that. With respect to copyright, I think Jean and Victoria said it very well. The only thing I would like to add is in terms of our mandate and our responsibilities as archivists, it is that idea of us having to provide access. And access, and as was said before, copyright and its legislation can support, in some ways it restricts, but it does support access. And we have to be mindful of the rights of the persons who are the creators, including ourselves in some cases, so that Copyright Act impacts lawful access, and the exceptions that the Act provides, especially for archives, really promotes research and education.
Thank you. That's a very good start, laying out the general principles of what we're talking about. I wonder if I could invite the panelists now to give us a few examples about exactly how copyright intersects with the work that we all conduct as archivists. And Jean, perhaps I could start with you asking for some examples here.
Well, I think copyright laws across the world are structured in a very similar way, setting out the exclusive rights of copyright holders, but also setting out exceptions to those rights for socially beneficial purposes like education, research, and that sort of thing. And archives are often the beneficiaries of those exceptions. So I think it's extremely important that national copyright laws have robust exceptions that enable archives and libraries and museums, cultural heritage institutions, to fulfill their mission. So that would be a general example in the ways that access and copyright law meet.
You. Avril, do you have any examples to bring from your experience with copyright in Caribbean archives?
Yes, I actually jotted down two very specific examples. Very easy one, well, at least we thought it was very easy, in that we were having an exhibition in-house about our carnival. I hope everybody's aware, but we do have a carnival festival every year. And of course, it includes music, performances, costumes, etc. And we had recordings of calypsos, and which is the music, and of course, images from the performances and the parade. And that was part of the exhibition. And we thought, well, it's in-house, it's inside the archives, you're not putting it online or anything. So no issue there. However, in our advertising, as we put out our flyers and so on, the CUT, which is in Trinidad, the Copyright Organization of Trinidad and Tobago, contacted us and advised, no, you are not able to play the music or play the videos without their authorization, because it is literally performing the music in a public space. So we had then, they did have provisions for such things as libraries and archives putting on exhibitions where we are allowed to pay like a standard fee for the year for the amount of exhibits we think we may have, and it goes into the coffers where they provide royalties and so to the artists. But because we don't know how many we may have, how many times we may use a record, they have provision for us to use one, like a standard fee that we can pay for a year annually so that we will be covered for such things. But we never even thought of that as being an issue because we said it's in-house, it's not, we're not paying, it's free, etc. So that was one. And the other one is our audiovisual material. So we are only recently highlighting a lot of our audiovisual. We've been digitizing, and putting things online has really been a challenge with respect to the audiovisual material. Now, everybody's really keen on getting access to that sort of images, videos, and so on for their own works, but as well as education and research. But it is a real challenge for us. So in the end, when we got some advice from our IP office, and we simply had to decide only in-house. Can you come into the search room? You can review, you can look. We have a station set up where people can view the material. You're not allowed to copy or download. And the responsibility for getting the authorizations, the copyright, if you want to reproduce, it's in the hands of the researchers. And we actually got IPO to guide us in crafting a statement, which users sign. So they make a declaration in terms of how they use the material. So we can provide access, but we try to put in place as much as the restrictions as possible to protect the rights of the copyright holders.
That's very interesting. Victoria, have you got some examples for us?
Yes, that's a great example actually, because I would have started my comment by saying it doesn't usually affect access to the physical work itself, but obviously in the case of the example you just provided, it did affect, or copyright has affected access to the physical work. And I guess that's often the case with audiovisual material, because of the complexity of the rights involved, and because there are often collective management organisations that have an interest in the work. So organisations that exist to represent the rights of rights holders in a particular sector or industry. So that's another aspect of kind of the management of copyright that we need to be aware of, and how that can impact access. An example that I could draw on in terms of access that I've come across recently is the experience of the Dutch National Archives. So this is one of the first examples that I found where the institution has access to an extended collective licensing scheme. So again, they can form a contract with a collective management organisation. And by negotiating certain forms of access to their collections, they can digitize those materials and make them available online for research, for personal use, for education purposes. But again, they benefit from a very strong collective management tradition within the Netherlands, and that allows this particular process to happen. So in addition to exceptions and limitations that we're all probably familiar with, whether it's a preservation exception, a personal use exception, educational or other exception, there are other mechanisms that copyright law can permit to occur, particularly in jurisdictions where they know the rights holders' interests are protected and maintained by these collective management organisations.
Thank you very much. I think what those responses are telling us is that within different legislations, there are a variety of legislative clauses and mechanisms which can facilitate access by leading towards exceptions. And some of the things that I picked up there make me reflect on the possibility that some legislations specify that if something is not for profit, then it might have a privileged position in respect of copyright and access. It was also mentioned that there could be a distinction between circumstances in which people come into the archives as opposed to remote access, where restrictions might be stronger. And some legislations make that distinction very, very strongly. And then that a small number of legislations, smaller, unfortunately, make exceptions where something is clearly in the public interest. I suppose that's a form of not-for-profit, but it's stronger, I would say, than not-for-profit. So you have those categories where archivists may be working with legislations where not-for-profit activities are privileged. They may be working with legislations where if you come into the archives rather than doing something remotely, you have a privileged exception that may be available to you. And if you can argue, so not-for-profit and public interest could be strong reasons which enable archivists to do things which make their work possible in terms of access, but also exhibition and other normal activities for archivists to conduct. One interesting point that Victoria raised there was in respect of collective licensing. Now, I'm among those who's got quite a bit of skepticism about the value of collective licensing in the world of archives. But one of our panelists has got even stronger views than mine. Jean, you've written really trenchantly on the subject of collective licensing and archives. Would you like to just share a few of your thoughts, which are in print and well known, about why collective licensing has only a limited value as far as archivists are concerned?
Thank you, David. With pleasure. Licensing usually involves payment of some sort. You know, the beneficiary of the license would pay the collective management organization some fee in exchange for the permission to do whatever it is, digitize and put online, for example. The collective management organization would pass some of the money on to the rights holders. Because archival material, for the most part, was not created for commercial purposes, I see no reason why we should have to pay license fees. I see license fees as quite frankly, a money grab that archives in particular should not have to pay in order to fulfill their mission, particularly with regard to digitization, which, as we all know, in the global information environment in which we work, people expect things to be online. So I understand licensing in economic terms can be a very efficient mechanism, but if archives are going to have to pay licenses, they should be zero rated. They should be free. Just give us a license, and we do not have to pay anything. So that's a hard sell with CMOs.
It is, and we ourselves and those of us who work with the World Intellectual Property Organization often find ourselves in the company of museums professionals and library professionals, and people don't always understand the difference and the reason why the uniqueness of within archival collections makes collective licensing so much less of a natural process as far as archives are concerned. It's a message that we have constantly to keep repeating within those World Intellectual Property Organization, WIPO, OMPI circles. Thank you very much, panel, for your thoughts on the examples. Can I move on now to a different issue, which is about the way that national legislations, individual national legislations, intersect with the international copyright framework within which we all work. Is it your view that there's no such thing as international copyright, or is every legislation national and separate from every other one? And how do we see work within national legislations interfacing with the international framework in which we increasingly have to work in a digital age? Victoria, perhaps I could ask you to start on this.
This is a tricky question. I guess in terms of the international framework, we're really referring to the Berne Convention and to the various WIPO treaties that exist. And I think we can say that international copyright law exists as far as how frequently those treaties are actually enacted into national legislations. I think what we take from the Berne Convention, I guess, is the kind of the three-step test still exists. So the kind of the prescription that limitations and exceptions should not be overly broad, that limitations and exceptions should not rob rights holders of a real or potential source of income, that these limitations and exceptions shouldn't do disproportional harm to rights holders. I think those kind of principles are still visible in our national and occasionally supranational laws if we think about the way that European copyright law works within the EU, for example. I'm just thinking back to the original question. I guess it's the main aspect of the interaction of these different frameworks that I would take away from this is the fact that when we put material online, we are effectively kind of interacting with other jurisdictions' copyright law and with international copyright law in general. So a lot of the work that we do in terms of digitization, providing access across borders, is impacted by those international laws.
Yeah. Avril, do you have any thoughts on this, the intersection of national legislations and the international copyright framework?
Yes, David. In our instance, specifically Trinidad and Tobago, similar to what Victoria said, we have signed on as a nation to many of these treaties, including those mentioned by her. And I just wanted to add the Marrakesh treaty, which we recently did. And in most cases, I made a check to make sure that they've actually amended the law, the Copyright Act and the Intellectual Property Act, to treat with those that they have actually signed on to, which they have agreed. So they can implement locally as well. So to that extent, there is that global effectiveness. The Marrakesh particularly, they had to authorize a body, and it is our National Library, not the National Archives. However, we're all guided by and the work that they do so that we get access as bodies to the material that produced for the visually impaired. On the other side, we have locally, I'm mentioning again our carnival, and I'm using the term mass because we say mass here, more the portrayals. What we have done in the definition of what is copyright and what material is copyright, when they talk about literary works and so on in their definition, in our act, we have added what we call works of mass. And so instead of the definition simply, well, I'll just read, quickly, what we've inserted. All right, so in the definition of an original production intended to be performed, so they've included what is called works of mass. This is an original production intended to be performed by a person or a group of persons in which an artistic work in the form of an adornment, image, and well, they go into great detail of it. This is now then considered part of what works that can be copyrighted. And it's not included, of course, in international. There's a more generic, just literary or otherwise. But for us, works of mass is critical to our cultural environment. So it had to be clearly defined. One of our experts in this area, Dr. Sharon Legault, has pointed out that although we have included it locally and internationally, they've lobbied and been part of the discussion at WIPO to talk about that sort of inclusion. Its application internationally is very limited. So locally, we are now able to treat with some coverage for copyright being represented for works of mass, but it's still a work in progress to get it, I guess, to the international level and global level, because there are works of mass, of course, outside of Trinidad and Tobago.
Thank you.
So that's my example of that.
Good. Jean.
Yes, copyright is a national regime. Every country has its own copyright law, and it may be very different from the copyright laws in the countries around it. The way international copyright works, sort of, is by means of treaties. So if for example, Canada and the US have signed the same treaty, you know, the Berne Convention being the grandmother, if you will, of all international copyright treaties, that means that the way it works is through what is called the rule of national treatment. So if the work of a Canadian is being used in the US law applies. If the work of an American is being used in Canada, Canadian law applies. But American copyright law and US and Canadian copyright law are quite different in a number of respects. So in the global information age in which we work, you know, the borderless work of the world of the internet, the whole copyright system is bound by national borders, and the copyright laws across the world are, particularly with regard to the exceptions that benefit archives and libraries and museums, are very inconsistent. Some countries have very, very weak exceptions, or exceptions that exclude archives entirely because they only apply to published materials. Other countries have very broad and robust exceptions. And so while our work at WIPO attempts to create an international treaty that will establish at least a minimum level of the necessary exceptions that are needed for cultural heritage institutions, there is a lot of work that needs to be done at the national level. You know, if we can't get the treaty, at least we can improve our national laws.
Thank you. And of course, we're trying to do our bit, some of us, with introducing toolkits which are not quite treaties, but which should help in this sphere of exceptions and limitations that Jean's referring to. Within that world, if I could just pick up the point that Victoria made about cross-border working as well. The toolkits which are being developed within WIPO, the first one, which has been completed, is on preservation. The second one, when it emerges in due course, will be on access, which is our theme for this International Archives Week and a principal thing that we're talking about today. And then the third toolkit into the future at some stage will be about cross-border problems to do with copyright. Do you perhaps Jean in particular, do you think those are the right three topics as far as archivists are concerned: preservation, access, and cross-border working, or is there something missing in terms of exceptions needed in WIPO?
Well, I'm not sure that there's anything missing, but the whole idea of access needed to be dealt with in conjunction with the preservation toolkit, because there's absolutely no point whatsoever in preserving something if it can't be made accessible. Mm-hmm. And I am not a member of the group that is putting together the toolkit on access, but my understanding is that the mandate given to it by WIPO is regrettably more limited than is necessary for institutions whose fundamental mission is to, preserve and make available for use their holdings. So I'm quite disturbed by the apparent reluctance of WIPO to diminish the importance and the breadth of access in developing toolkits that are supposed to be helpful.
Thank you. Okay, well, we'll see what develops there later this year in Geneva. Can I move on to the next area where I'm going to ask our panelists to reflect upon, and it's myths and misconceptions. So to invite the panelists to talk about what they've encountered by way of myths or common misconceptions, and what follows from that, where they come from, and so on. So Victoria, perhaps if you could, you've got any myths or misconceptions for us?
I think the one that I come across most frequently is if you own the physical item, you also own the copyright. I think that's a real trap that we tend to fall into. I'm not sure where this assumption comes from. I think it may simply be an issue of copyright literacy in the sense that copyright is an intangible intellectual property right, and the assumption that it transfers with the physical item is probably an easy one to make. I think another common one that I've come across in discussions with archivists, but also with volunteers, is that once something is published in a newspaper, it's in the public domain. And I think that is a specific confusion around the meaning of the term public domain. So obviously public domain has a meaning in the sense of once a story or a particular set of facts about a particular event, a news event, are in the public domain, that is one interpretation of that term. The other interpretation within copyright law is that when a work reaches the end of its copyright term, it's in the public domain and free use can be made of it. Or if the work never qualified for copyright protection in the first place, if someone waives the rights to copyright in the work, it enters the public domain at that point. That doesn't mean that you can digitize the work and put it online simply because the newspaper facts are in the public domain. There is still copyright in the newspaper story itself. So I think those are two that I've definitely come across in my work. And again, I think it's an issue of copyright literacy in terms of how much copyright we're able to teach on professional archive and records management qualifications, and also our kind of the amount of experience that we build up with copyright once we're actually in post and working in archives.
Thank you very much. And I must agree that distinction between the ownership of the document and the ownership of the copyright is one that trips up a lot of people quite frequently, and it's probably more important for archivists than it is in the other cultural professions, because of the fact that archival items are unique, and so the ownership then is the two types of ownership are a very important issue for us. Thank you, Victoria. Avril, would you like to comment on myths and misconceptions?
Yes. So I have one which is quite similar to what Victoria said, related to but government records instead of newspapers. That everybody believes it's produced. If it's produced, it's printed by some ministry, some organization, the government. It's public record. It belongs to them, so there's no copyright. But they may not be aware of how, as we have learned ourselves the hard way, what agreement the government went into to produce the material, what contractual arrangements were in place. And actually, we had an incident where the government got into some sort of agreement with an author to produce a document about, well, let's not go there, to produce a document. And when the document was at the archives, and we thought, well, okay, we're going to put it out there for people to view. Again, we was getting trapped with exhibitions, putting it out in an exhibition. And the author complained and said, well, we have no right to reproduce her work, put it on slideshows and so on, because the government paid her for one-off, and they had an agreement which said she would do X, Y, and Z, and it said nothing that it belonged to the state. So it's, as far as she's concerned, it still belongs to her. And so we need to be mindful that there are copyright issues which occur, although it may be a government publication on the outside from where the John public may look at it, unless we're clear what the arrangements were for the production of the item, and it is a public record or produced by the government or by the state, then we can't say, okay, we will go ahead and reproduce or use it for other purposes.
Very good. Jean, myths and misconceptions?
Well, of course, the most common myth we've already talked about, which is that the belief that the ownership of the physical item also includes the copyright, and that is evident. I think every archives has had people saying, "Can I have your permission? The permission of the archives to copy this or publish it or do whatever." And they have great difficulty understanding that we don't own the copyright, and they and pointing out it's up to you to track down the copyright owner, which is an awful lot harder to do with archival material than it is with published material. But the myth and misconception that I have come across within the ICA is a little bit different, and it's the conflation of access restrictions and copyright. I have had several people tell me, "Oh, we're fine with copyright because we've restricted access. We're good on copyright," and that they are two entirely different things. And quite frankly, some of the people who've told me that should know better. So that's a little bit different than some of the more common myths, but it's one of the reasons why I thought it was important to develop a course about copyright.
Good. Thank you very much, Jean. I'm just looking at making the best use of our hour together here. I'm noting the fact that we've got between 220 and 230 participants. It's going to be really difficult for me to sort through the questions from the audience, and I've still got a few things that I like to ask our panel. So I hope the audience will bear with me if I'm going to be squeezing the time available for questions and comments, on the basis that it will be possible to put those questions and comments in different forums within ICA after this webinar. I'll try to take a few questions at the appropriate time, but I think we've still got a few important matters to discuss with our panelists, and I hope everybody will agree that that's the best use of our time. I'd like to ask the panelists now about your own perspectives and your own experience, and the way that that gives you a view on what are the main challenges that relate to archives and copyright and access that archivists are facing at this moment. Victoria, would you like to start with us?
I think the main challenges, based on my own experience, I think are convincing institutions to get comfortable with uncertainty and taking a certain amount of risk. I'm not suggesting that we start infringing copyright en masse. That's obviously inappropriate and it goes against our ethical codes of practice. But for older materials, material that was not created for commercial purposes, I think the benefits of making it available to a wider audience generally outweigh the risks of infringement. I also think one of the challenges that we need to address is looking at how we make traditional knowledge available, developing relationships with communities to manage that material in a more sensitive and a more collegiate way, and also making sure that we're not making material available online that shouldn't be made available online. So thinking about the kind of the access processes that should be in place for that. So on one hand, I'm saying we should be making more material available. On the other hand, I'm saying we need to be more sensitive with the material that we're making available online.
Thank you. Avril, challenges?
Well, there usually no ends of challenges when we have to deal with things. However, we have to limit them. I would say I had divided it into old and new. So the old, which was the items where we have no documentation, and that is a sore point for us. We have material in the archives that may have come to us for which we don't even have institutional memory. And so ascertaining the copyright or the what conditions under which they were acquired and those sorts of things are difficult. So even on our end, it's difficult to provide access. Well, I'm mindful of what Victoria just said, but let's say safely, especially as a government archivist, we have to be very mindful of those risks. And so we want to provide the access to the material, but we really have to do a lot of due diligence where there's no documentation. And that, again, is a serious challenge that we are facing with issues related to copyright. And then sometimes we have the material people want to reproduce and they come to us and say, do you have information about so? We got it from you and we can't have them. So they have to go do their own research and try their best to see if they could locate the copyright. In terms of the new, the challenge, and I think that's there for all of us, is of course our digital environment. It's changing faster than we can breathe. And every time we think we're on track, with 10 steps behind, with this wave of how things are done digitally and where our copyright lies, where our responsibilities lie. In our area, in Trinidad and Tobago, and I think regionally, I would say the legislative and regulatory environment is a real challenge in keeping up with that issue in the digital world. And again, the idea of being careful, we're being so careful about what we could actually put up, we're cheating the public because everybody expects things to be online, available freely, etc., and easily. But it's not so much that we don't have it or we don't want to put it there, but again, those risks, especially as a safer government institution, is very real. So that is really a challenge. What we've been trying to do with that to mitigate is, of course, putting out there everything that we're really sure is out of copyright. So we kind of using that to advertise, promote, get people to know that this is what we have, at least those aspects of the collections. And as we did with the audiovisual, provide the others in-house and with the restrictions as best we can in the interim until we're clear in terms of the legislation, what is related to what those relevant collections. So it's a little trade-off.
Thank you. Jean.
Well, there's no end of challenges, but I will stick to two. I think one of them is modernizing our national copyright laws to address copyright in the digital environment, as Avril has said. But that is dependent on the second challenge, and that is copyright literacy within and across our profession. And I would say the general public needs to know more about copyright as well, but I'll start with the archival profession. That's a big enough challenge on its own.
I'm going to ask one more thing of our panelists. Just before I do, I'm going to select maybe one or two questions from the chat and the questions part. So one which caught my attention is about it relates to what's been mentioned earlier about traditional rights and historic guardians of manuscripts in situations where the manuscripts are of considerable age. So this is a question that's come in from Archive Nepal, where they're saying that they're planning a project to digitize manuscripts that are over 100 years old and so are in the public domain, but they're being held sometimes by private individuals or by monasteries. Is there a mechanism? So the questioner wants to check if the guardians of these manuscripts have any rights in respect of holding on to public domain materials which they want to digitize. Challenging question. Would anybody, I know that we're not experts on Nepalese copyright on this panel, but Jean, thought on that?
It's the difference. It's an issue that we've already talked about, the difference between the ownership of the physical property and the ownership of the intellectual property in it. If these private sector individuals own the physical property, there's no obligation for them, except, no obligation. They would take persuasion and possibly some incentive. I don't know what the situation is to get them to permit their property to be digitized.
Thank you. Yeah, that's the answer, isn't it? Yeah, the other panelists are nodding. But I'm going to go to a last point to the three panelists and ask you to say, in just a few words, one thing that every archivist should know about copyright. So a final question for our three panelists. Can I start with Avril? One thing that every archivist should know about copyright from your perspective.
I thought a little bit about this and I was wondering really what is the one thing, but I'm going to go back to the beginning on when we started on what copyright really means. So I'm just going to read what I actually had here. Copyright entitles the owner to economic benefits to their work and moral rights to the proper use of their name. And it's much more detailed than that, but basically. And it is not meant to stifle knowledge or creativity. And as archivists, we are charged with an ethical responsibility of walking that thin line. I think we've said that, or everyone has said that as we've been speaking. So we need to know and understand as archivists our responsibilities, but also to honor the creator and make sure that they are treated fairly and ethically, I guess, in terms of the works and their work and their products. So I think that balance and understanding our responsibility in that balance is something really important for us as archivists.
Thank you. Jean, one thing that every archivist should know about copyright.
There's a quote I often use in workshops, and it's along the lines of perfect certainty in copyright matters is extremely rare. And so archivists must be a lot more bold about taking risks and staking out as much territory as you legally can in order to make our material more accessible.
Very good. Victoria, your one thing.
I think in addition to the distinction between the physical property and the intellectual property, I would also point out the difference between the concepts of authorship and ownership. So even if the rights holder in a work is a corporate entity, for example, duration is generally determined by the life of the author, who may have been an employee of the corporate entity, but duration is generally determined by life of the author. So yeah, a distinction again between different concepts in copyright law.
Yeah, so I think what I'm going to do now is draw the question and answer session to the panel to an end. We're into the last 10 minutes of the time allotted. I'm aware that I'm squeezing out questions and comments from the audience, but I hope they'll understand that I would really struggle to work on a show of hands with 230 people here. It's wonderful to have so many participants, but I think the questions and answers could still continue once this session has concluded. So thank the panel very much for their questions. The next item on the agenda for this webinar is a presentation of the new ICA course called Introduction to Copyright for Archivists. And I'm going to ask Jean to start on telling us a little bit about this new ICA course being launched now. Jean, over to you.
Thank you, David. Well, needless to say, I am delighted to see the official launch of this course that I've been working on for more than 5 years, and there were certain ups and downs and setbacks during those 5 years. You may wonder why I undertook this project. As the representative of ICA to WIPO's Standing Committee on Copyright for 9 years, WIPO from time to time asked for additional ICA representation at particular events, particularly from the Global South. But unlike our partner, IFLA, ICA has no cadre of people from the Global South sufficiently knowledgeable about copyright in our profession that I could readily call upon. And more recently, external funding has been available to send representatives to WIPO meetings to better understand the issues facing us, but I did not know of anyone from the Global South who could knowledgeably represent the ICA. So my conclusion was that education about copyright within the ICA is urgently needed, so I created a course. And it proved to be one of the most challenging projects I've ever undertaken. I'm quite accustomed to teaching Canadian copyright law and American copyright law, and I could do a pretty decent job of developing a course on copyright within pretty well any British Commonwealth country because of similar traditions. So teaching copyright at a national level is relatively easy, but teaching copyright at a global level is a different matter entirely. There's no overarching international copyright law that applies to all countries. And as I've said, every country has its own copyright law, and the law that applies is the law of the country where the copying or dissemination takes place. So therefore, this course had to be written at a very general level because we can't discuss every possible national variation. But it couldn't be so general as to be absolutely meaningless. So within the course, I've tried to make general statements that apply to most situations, but I know that somebody will come up with an example that contradicts my general statement. It doesn't mean the course is wrong. It just means that there's great variation in national copyright laws. So let's take a very quick look at the course itself. I think Avril is going to share her screen. There are 9 sections you can see along the left, starting with the course overview. Section 2, what is copyright, explains why archivists need to know about copyright and sets copyright in a context. Sections 3 to 6 cover the core provisions of copyright law, the scope of copyright protection, what isn't protected by copyright, the exclusive rights of the copyright owner and the author, the rules about copyright ownership and how long copyright protection lasts, and Section 6 explores the exceptions to copyright protection, which permit archives to legally make copies, to preserve their holdings, and serve their users. Sections 7 and 8 look at how to put the law into action. Section 7 talks about the need for advocacy at the national and international level for better copyright laws and suggests some strategies for doing so. Section 8 discusses strategies for managing copyright in your institution. and that it will be supplemented by a forthcoming toolkit from the expert group on legal matters. And section 9 is a brief summary of the course. So within each section, there's a video with the voiceover, the video script, and the slides are available, as are the exercises, additional resources, and the quizzes, which you must pass to earn a certificate. The exercises are optional, but taking the time to work through them will create a dossier about your national copyright law that will be an invaluable reference tool. So I invite you to register for the course, and I hope that you find it useful. Back to you, David.
Thank you very much, Jean. I'm aware that we're running short of time and we need to close down shortly. Just one question that's come in. Has the course been drafted recently enough to cover AI implications? Will that be part of the course, or is that for a future course?
That would be a future course. I just gave a webinar in Canada about AI and copyright, and very few countries have amended their laws to address the AI issues. There's a lot of consultation about what are you doing? We don't have a clue what to do. What are you doing? But there is nothing to speak to, except in a very few countries. So it's a future matter.
Future matter, okay. So I'm going to draw this to a close now by firstly thanking the audience for turning up in such wonderful numbers. It's really heartwarming for us, having contributed to this panel, to see so many people signing in for it. And then on behalf of all the audience, I'd like to thank our wonderfully knowledgeable panel, Avril, Jean, and Victoria, for their contributions. Lots of things for all of us to think about further. And this is just one stage in a process of learning about archives and copyright. So I'm going to hand over now to the organizers of the webinar. And what I have to do is to switch off my camera in order to do that. And then we move to the sign off. Thank you very much, panelists. Thank you very much, audience. And we'll see you next time. Thank you.